My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me about. The notice of claim periods are quite a bit shorter than the statute of limitations. So typically, if you have a claim against the government for injuries, you have to file a notice of claim within 6 months after you've had the injury, or your claim will be thereafter barred. So in the state of Oregon, if you have a claim, you need to consult with an attorney to find out when the statute of limitations runs, because it's going to vary. So although the 2-year period is the one we're generally dealing with, that's not true in every case. And the only way to know whether it's true or not in a given case is to check it out. So I hope that's information is of some use to you, and I'll look forward to talking to you if you need my help. Thank you.
Hi, this is Jim Sellers. I'm a trial lawyer, and I practice in Oregon and Washington. I represent injured people. I have a few comments to share with you regarding how cases are affected by value factors, which I'll talk about. I did a prior video on how cases are evaluated and value established, but I want to tell you about factors that you would never even think of that can affect the value of a case. The first of those being any biases jurors might have. As for instance, I think on every jury, during jury selection, we have jurors express reservations or opposition to awarding damages to the plaintiff for pain and suffering. Now the law is clear that you're entitled to recover those damages, but the insurance industry and big businesses put so much propaganda in the airwaves about personal injury claims that very often jurors come to the jury box with the belief that this whole system is just a big lottery, and if you hit it, you make a lot of money. Well, it doesn't work that way. Anybody in this business can tell you it doesn't work that way. It's very difficult to recover what you're entitled to, and oftentimes you don't recover that. It's pretty rare that there's any excess amount that the jurors award. Jurors have a lot of common sense, and they're not likely to do that. So one of the things we have to do to keep that from becoming an adverse valuation factor is during jury selection, we try and educate the jury as to these issues, and we try to disqualify those people that are very biased, at least biased to the point where they can't render a fair decision. As for instance, if they say they won't award money for pain and suffering, we can disqualify those people. The next factor is the person of the plaintiff themselves. If the plaintiff is a person with whom the other jurors can relate, that does a lot. If the jurors perceive that there's something they don't like about the plaintiff, in other words, the person who's injured, they'll tend to hold that against them for reasons which you would never even imagine. So for instance, if you have mainly an elderly jury, you can expect that jurors will probably be more sympathetic to an elderly plaintiff. If you have your average middle class, working class jury, and the plaintiff is to give you an extreme example, a Hell's Angel and dresses like it, that's probably not going to work very well, and the jury's going to be completely unsympathetic to that plaintiff. Just on the matter of dress, I always counsel my clients on dress, and I take my own advice in terms of what I wear myself at trial, but I don't want them to overdress, and I don't want them to underdress. Above all, I don't want them to show up to trial in blue jeans and flip-flops and a t-shirt. They don't have to wear a suit and a tie if they're a man, or a dress if they're a woman, but if they dress plainly